What am I talking to you about? I'm talking to you about metamorphosis. I chose this as a word, means literally changing in form. And what I'm talking to you about today is how society, through the criminal justice system, demands that offenders change themselves. Now, first line, we want them to change their behavior. Ideally, we want them to change their values. But we also ask them sometimes to change their form. So the question I want to put to you is, what biological interventions can a society legitimately coerce an offender to accept as a rehabilitation treatment? So let me tell you just quickly about how the criminal justice system does coerce consent to treatment. Well, it happens at many stages of an offender's transit through the criminal justice system. In fact, they can be diverted at the outset if they show a willingness to accept treatment. There are courts called mental health courts, drug treatment courts, frequently a condition of which is that you acknowledge guilt and accept treatment, and thereby are diverted from the usual process of the criminal trial and sentencing and punishment. At sentencing, judges commonly will comment, in Canada, I'm talking about Canadian law here, comment on the extent to which the offender shows remorse and accepts responsibility. And this is willingness or refusal to take treatment is commented upon favorably or unfavorably as evidence of remorse and responsibility taking. Furthermore, an important part of a sentencing decision is to find out what the prospects are for rehabilitation and the continuing risks of the society, whether there's a need for incapacitation of the offender in jail. And again, treatment is very influential in assessing all of these things. Most of the dangerous offenders in Canada, or a large proportion of them, are those who committed the sex offenses, but also other forms of physical violence. Parole and probation, again, are discretionary decision-making, also where willingness to take treatment and risk you pose factor as part of the decision. So I come back to this question: what biological interventions can a society legitimately coerce an offender to accept as a rehabilitation treatment? So one could adopt a number of normative frameworks here to try to answer this question. But I'm going to be sort of a pragmatic lawyer and say, well, which are the ones that I think would apply if this dispute arose? Although the mothers might. One might look at this from the perspective of the offender and the virtue ethics of whether the offender should change himself in this way or not. I'll set that aside and instead say, what are the normative frameworks that will apply to the powerful actors in this system, to the judges and the state, and to the doctors who will provide this treatment? So these are the limits provided by the Constitution. The human rights guarantees would apply to the judge. So this is not lost, as I mentioned, on the people who are before the courts. And so I thought perhaps I would just take a few quotes from a recent Canadian case involving a sex offender. So within the judgment, we see that the psychiatrist, quote, informed KO that because he was not willing to take anti-androgen medication, chemical castration, the psychiatrist would recommend KO be designated a dangerous offender. Further on in the paragraph, the judge observed, KO then reconsidered his position and told the psychiatrist he was prepared to take Lupron. So you can see it playing out and acknowledged the influence. And indeed, I'm agnostic on whether this is wrong or right in this instance. I'm just trying to describe a pattern and ask you questions about what the limits on this practice are. So what about tomorrow? A couple of quick words here. I wonder about the use of deep brain stimulation in this population. You might say, no way, we're not going to apply brain surgery to criminals. Well, we have already. We have done it in the past. And when you think about the cost of incarcerating a dangerous offender for life, a DBS starts to look not unreasonable. Obviously, this wouldn't be offered to low-level criminals, but the serious ones. Vaccines for drugs as well is something I find very interesting. And I'll use colorful and somewhat metaphorical language here, and like veering over to our friend Michel Foucault for a moment. What's fascinating about the idea of using vaccines in this kind of way is what it essentially does is it takes the prison walls, moves them within the body. You actually conscript the offender's immune system as part of the state apparatus to modify behavior. You can get somebody to want corporal punishment, lobotomization, or sexual castration of sexual offenders by making the alternative sufficiently unpleasant. So if we say that cruel and unusual punishment is only when forcible application of this treatment is provided, we provide the state an awfully useful loophole to get out from that constitutional protection. Just make the alternative sufficiently unpleasant, the offender will want it, and not cruel and unusual. factors that allows this to happen is the fragmentation of the judicial and the medical roles. So if you read the cases, you'll see that the judge, in providing these orders, you are to receive treatment, will never specify what kind of treatment. They always say, you must take treatment as is recommended to you from time to time by your doctor. Makes sense. Judge doesn't know medicine. Offender's condition might change over time. How can a judge forecast what the needs are going to be and whether treatments will work? But the judge doesn't have to take into consideration the nature of the treatment that might be applied, and instead can outsource that part and not ever have to scrutinize the particular treatment applied. The doctors, on the other hand, receive the offender without having participated in the creation of the coercion and are able to distance themselves from the coercive aspect of the situation. I'm just providing help at the request of a person in a real bind here. So what I'm suggesting to you is that this separation allows both parts of the mechanism to avoid or weaken the normative framework that ought to govern it. So there is a conscription or an involvement of physicians within the state coercive apparatus, the control of behavior. This may be fine, this may not, again, agnostic, maybe it's okay. But this is an odd form of beneficence to assist people to avoid the punishment of the state is now a form of medical beneficence. When one thinks of Alan Turing, who was subjected to chemical castration when homosexuality was a crime, this again was doing good to Turing to help him to avoid incarceration. So consequences and risks. Role fragmentation, as I mentioned, nobody has ultimate responsibility. It's a perfect example of one of Foucault's apparatuses where all the parts are busily doing their bit and no one having ultimate responsibility for the operation of the whole. Leads to this weakness of the normative limits that I've suggested to you and obscures the social and economic contributors to crime. And my suggestions, and here's where I'm out there floating a little bit and I'd love to know what you think. We need a way to look at this whole thing as a whole system and evaluate its rightness or wrongness as a whole rather than its individual chunks. And I think it might be an idea to have a clear articulation of the limits on the kinds of offers that can be made, and I say regardless of offender preference. We'll be in a situation of saying certain things are off the table even if an offender wants it. Thank you.